Yeah, please, Lordship. Item number 9, Lordship. Can it be taken up at 2, Lordship? That's
After
difficult.
2?
At 2, Lordship.
Yes.
I've taken the consent of other side, Lordship.
Yes.
Of life. Item
Item
number 9,
number
Lordship.
9 at 2, yes. Can be taken.
Yeah, Lordship. Also, with the other side, I beg to mention item number 13, 1-3, Lordship. Lordship, kindly matter will be taken after 3 weeks, Lordship. 1-3.
Fifteen, 16, 17.
Learned Counsel, Mr.
As they, behalf of UB Sharma.
A.S.
As they,
As they.
DEY.
As they, on behalf of Learned Counsel, Mr. U.B. Sharma, comma, with the consent of the other side, has prayed for adjournment. Is the matter after 3 weeks. 3 weeks? 3 weeks, no?
Yes.
Okay.
Lordship, I beg to mention item number 11, due to some personal problem, matter cannot be taken up today.
What problem?
Personal problem due to some. I've also taken consent from the other side.
Okay.
After on 19,
Learned Counsel, Miss
D. Goswami, on behalf of R. Goswami.
D. Goswami has submitted that owing to some personal problem, the matter cannot be taken up by the leading counsel, Mr. R. Goswami.
R. Goswami.
Full stop consent has been taken from the other side. List the matter when do you want?
19 February. 19 February.
Fine. On 19 February.
May I please, your Lordship? Lordship, with the consent of the respondent side, I beg to mention item number 19, Lordship. Matter kindly adjourned for 4 weeks, Lordship. My chair is out of station.
Learned Counsel, Mr.
P. Sharma.
P. Sharma, comma, with the consent of the respondent's counsel,
Yes, Lordship.
has prayed for adjournment. List the matter after 4 weeks.
And another place, my lord, with consent of the respondent side, beg to mention item number 15, 16, 17, Lordship. They are clear, Lordship. Matter kindly adjourned for 3 weeks, Lordship.
Learned Counsel,
Can you fix the date, Lordship? 2nd week of March.
all the three, 15, 16, 17?
15, 16,
1 day. 1 day.
1 day.
Learned Counsel, Mr. P. Sharma, with the consent of the other side, has prayed for adjournment. List the matter. Tinta. 17 March.
Obliged, Lordship.
Okay.
May I please.
Mm.
Lordship, with the consent of the other side, I beg to mention item number 18, Lordship. Lordship, this matter may kindly come up on 13th March if possible. Or after that, any other day.
Learned Counsel, Mr. S. Sharma, no?
SP Sharma, Lordship,
S.
for
P.
the
Sharma, comma, for the insurance company, comma, with the consent of the other side, has paid for adjournment. List the matter. What did you say?
19 March.
On 19 March.
So I have another prayer, Lordship, for listing of an MSc appeal. Execution proceeding has been initiated.
Honey, more remanded, more date diasu. Honey, you'll have to mention before Justice Rogan.
Obliged.
May I please, Lordship, I beg to mention item number 8. I am on behalf of Mr. S. Bonik, my senior colleague.
I'm for a petitioner, my lord.
After taking consent with the other party, I want to take adjourn for 2 weeks.
Which item?
8.
They want to file affidavit, my lord.
Will we file it?
You
today?
will file affidavit.
They want to file affidavit, my lord.
Will file.
That's why, my lord.
Who has mentioned about item number 9? Learned Counsel, Miss
T. Sarkar. On
P.
behalf
Sarkar, on behalf of Learned Counsel, Mr.
of S. Bonik.
Item number 8, my lord.
S. Bonik, comma, with the consent of the other side, has prayed for adjournment. Gustav, your name?
A for the judge.
Learned Counsel, Mr. A. Bhattacharjee, is present on behalf of Learned Counsel, Mr.
Oh.
Oh,
No, Mr. M. Nath, senior advocate.
on behalf of Learned Senior Advocate,
Yes, sir.
on behalf of on behalf of Senior Advocate, Mr. M. Nath has submitted that they will file an of.
I'm not.
Today we will be filing.
Okay,
of
okay.
affidavit.
Nalaya. Nalaya, it will also line to Nalaya.
Diploma. May I please, Lordship.
List to dila niki? Did us
It's 23rd February, my lord, technically problem.
fine it was. List the matter on 23rd February.
Hello.
Hello. May I please, Lordship, I beg to mention item number 22 of the supply list, Lordship. Yesterday we have filed a dusty affidavit. I am appearing for the applicant. We have filed a dusty affidavit yesterday. That may be brought on record today.
Okay. All right.
Much obliged.
Item number 1 on mediation.
Any element of settlement?
Actually, no, because our vehicle, the vehicle insured with our company is not responsible for the accident. However, the learned member has sustained the entire liability upon us.
Earlier, this was matter, this was, whether this was referred for mediation.
Last week
Learned
it was
counsel,
admitted.
okay, no element of settlement.
Hello.
Learned counsel, Mr. S.P. Sharma has submitted that there is no element of settlement. Learned counsel, Mr. Triple S. Roman is present for respondent.
Number 1,
Huh?
respond number 1.
Respondent number 1. This case is pending at which stage? We'll bring it to that stage.
Lordship, the service is complete, Lordship, but LCR reminder needs to be sent. Lordship.
Okay, issue reminder to for the LCR. List the matter after 2, 3. How many weeks?
My lord, date may be fixed, my lord.
Lordship, from
Date that
Kamrup,
date.
so after
Huh?
from Kamrup it will come. So Lordship, after 3 weeks, 2 weeks, 3.
A date may be fixed, my lord. Date may be fixed.
Second
Right.
March?
Mal.
Second March?
Okay.
Highly applies.
There's no scope of.
Earlier also it was listed in the mediation column. That order itself is there, Lordship.
Learned counsel, Mr. A. Is present for the appellant, and learned counsel, Ms. R. Chaudhary is present for the respondent number 1 to 4. Both the sides have submitted that there is no scope of settlement. It is submitted that earlier also this case was fixed for mediation. This case is not to be fixed for mediation anymore. List this matter at which stage?
Hearing.
Hearing.
You see on the-
List this matter for hearing after. Shall I give the after 2 weeks, 3 weeks?
2 weeks.
After
Lordship.
2 weeks.
Obliged.
Mm.
May it please your lordship. In this case, your lordship, an amount of rupees 11,68,000.
So it has come from mediation.
Only
So
mediation.
it's
No,
not-
I understand, your lordship. We have filed an interlocutory application, your lordship.
We cannot consider today.
Because, yes, your lordship, then may fix,
Pass any order.
fix a date, your lordship.
Short,
A short date, your lordship.
2, 3 days, after 2, 3 days.
I understand, your lordship.
Learned counsel, Mr. T. Devi is present for the appellant, and learned
I am
counsel.
for the appellant, Lordship. He is
Okay,
the
okay,
applicant in the
okay.
I.
He is present for the claimants, and learned counsel, Mr. S.P. Sharma is present for the insurance company, full stop. It is submitted that there is no element of settlement. Most of this case shall not be referred for mediation in the near future. Okay? There's no element of
No,
settlement.
no.
List this matter, the short data, একদম short data.
On 17 February.
17 February.
Deeply obliged, your lordship.
Item number 4, 5, and 6 for admission.
I am for the respondent insurance company. Other side is absent.
Insurance company.
Your lordship will fix a date on the next week, my lord.
4, 5, 6 or 7 নাকি তিনটা? 4, 5 and 6. He is usually present. Today he is not present. The petitioners are not represented today. Learned counsel, Miss S. Roy is present for the insurance company. List this matter after 1 week.
Your lordship will fix the date.
Data read
On 19 February.
March of less.
Item 7. May it please, my lord. My lord, landlord tenant dispute. The present respondent is the landlord and I am the tenant, my lord. As per-
1 minute. This is for admission. Will I admit it or?
My
you
lord, may
will-
admit it and my lord, I fix the date. my lord.
No, my
If
lord.
you are resisting the admission, then we'll hear finally.
My lord, then it will be pending. It is a concurrent finding.
No,
Both
it
the
won't be
courts-
pending today only. I'll hear it finally.
Finally,
If you are ready.
yes, my lord.
I'm
Let
ready.
it be here finally, my lord. On any day, let it be heard finally.
Ajay?
On any day, let it be heard finally. Of course.
Okay, you can start.
Yes, sir.
Because what is the point? You will resist, then I'll hear on admission, then I'll think of whether I'll admit or not, and then if there is an.
Well, let me finally dispose it of.
Yeah, if there is any point to admit it as well, I'll dispose it finally.
In fact, my lord, there is no point to admit it and hear it at a longer stage. But today itself, your lordship can hear it and the
I'll only
matter may
admit
be
it on discount alone, madam, because he's resisting.
No, after admission, what happens, my lord? It is put in the baggage. It comes after 2 or 3 years. So that's why, my lord, if your lordship is admitting also, let there be a date fixed for hearing.
That I can do.
Yes.
Okay.
Yes. ठीक है
Date
sir?
fixed for hearing. Okay.
Let it be admitted and then let a date be fixed for hearing, my lord.
That's what I'm saying. If you resist, then I'll hear it, and if you won't resist, then I'll admit it and fix a date.
No, I'm agreeing to the last point.
Okay. Learned Counsel, Mr.
A. Iqbal,
A. Iqbal is present for the
petitioners.
petitioner and has submitted that the petitioner is aggrieved by what's your grievance?
My lord, the learned court has said, both the courts have held that, my lord, I am a defaulter. By judgment dated 28/5/2025.
By concurrent decisions of the trial court as well as the
Appellate.
appellate court of first instance, holding the petitioner to be a defaulter, which is not the case. Full stop. Learned Counsel, Mr. A. Sattar is present for the respondent caveator and has stated that the petitioner is indeed a defaulter. After considering the submissions at the bar with circumspection, this petition is admitted for hearing on date of the day. On 24th of February. 24th of February?
24th of February. ठीक है, sir.
Okay.
Yes,
Please
well.
come prepared on 24th of February. LCR আছে না? দুটা কোর্টের LCR আছে?
আমি
Hmm.
আমি ফেলে আমি ফেলে
আমি the side switch हो गया.
I'm for the respondent in this appeal. There are in fact two matters here. One is an appeal under order 43 rule 1R civil procedure code against an order of temporary injunction. In fact, the application filed by them before the trial court was rejected. As against that, they have filed the appeal. The appeal is pending. Appeal has been admitted. There is another
Appeal against order.
order
Yes,
of
appeal.
temporary injunction that was rejected. They filed an appeal. Appeal is ready for hearing, and in fact, the Honorable Supreme Court has passed an order.
Is it for hearing that?
My
Parties.
Must-
yes,
My ladyship, I'm
Yes,
appealing for.
yes, madam, there is another thing, my lord. There is another.
Require the LCR or you do not require the LCR?
No.
LCR is not required.
You'll need the LCR, no? You
LCR,
have annexed all the.
All the documents are there.
documents.
all the
My
documents.
ladyship, may I apprise one thing?
My
I
lord,
was on the virtual
this
mode,
is-
kindly allow me
there is
just.
another.
It was item number.
10.
10, man, I'm on the
Item number-
virtual
Item 10,
mode.
madam.
I'm on the
Madam, there
virtual
is
mode.
another
I'm-
application here. Made clear. Madam, this IA is there, filed by them, alleging violation of an injunction.
Violation of injunction.
So there we have to file our reply. Today we are filing. It's in the process of being filed. So that,
Okay, you'll have to file reply.
yes.
Mala, I was for the appellant and the
Lord,
applicant in that
no,
application.
No, my lord, we need to respond to this affidavit.
Yes, Mala, kindly give me
Time.
2 weeks time to file a
And otherwise,
a
your
reply to this
kindly have a
objection.
look at the order passed by Honorable Supreme Court.
Yes, the order, Honorable Supreme Court is
And
there.
We'll give you time.
Kindly give me
We'll
2
allow
weeks, my
time.
lord.
There is a direction to dispose of the appeal early. May that order lordship kindly see this. By the Honorable Supreme Court order has been passed on 5th of February 2026. In fact, this is an order passed by the Honorable Supreme Court in a SLP filed by the appellant.
No.
Sorry, by
No,
us
no.
against an order passed by the Honorable Court. So there,
We got an order of injunction, my lord. From
Well,
this
at
court.
our instance,
So
well,
after
I-
they violated and the violation application is pending against that order.
at our instance, my lord, in fact, my lord, that order was passed, my lord, at our instance, my lord. I'm leading, my lord, Mr. Saiwala. I'm sorry, my lord, My lord, at our instance only, my lord, we only requested, my lord, for the suit, my lord, and my lord, the appeal to be expedited. My lord, there's a pending order, my lord, which has to be complied with. My lord, that also has to be, my lord, done. My lord, there was an order saying, my lord, that
My
he
lord, may
shares.
kindly have a look at the first paragraph, my lord. First paragraph of this order. While we are not inclined to interfere with the impugn order passed by the High Court, we direct the FAO and the suit shall be decided expeditiously. So there is why there is some urgency in the matter.
Yes, we'll fix a short date.
Short date.
You want to file?
No, we want
Well,
to,
only
we want
one-
to counter this affidavit, my lords. They have
Well,
filed it today in the morning. After 10:30, they have served a copy on us and they want the hearing to be done as soon as possible. When there was an order on 5th, they could have filed it on 6th or 7th. Why did they wait till 12th?
My lord, let us have it on,
My lord,
if Monday, they cannot let it be on Wednesday, my lord, or Thursday.
On Wednesday or Thursday?
My lords, it will be perhaps some difficulty.
my lord, may I just submit one thing? My lord, may I just,
My lord,
Mr. Saibala, may I just submit
for early
with
disposal?
my lord's leave, my lord, may I just submit one thing, my lord?
Yes, yes.
Kindly see, my lord, there's an order of,
Can you increase the volume of the speaker? I cannot hear you properly.
I'm so sorry, my lord. My lord, can my lord hear me now, my lord?
Yes, yes.
I'm so sorry, my lord. I'm so sorry, my lord. We are not there, my lord, physically. My lord, there's an order of 8 January 2026. My lord, kindly have a look at the. No, the main order. My lord, kindly look at, my lord, the
28 January.
8 January.
Yes.
28 January 2026. My lord, you'll find, my lord, in that order, my lord, paragraph 48.
28th January 2026.
28th, yes, my
That
lord.
was Justice Mridul Kalita's order wherein they had violated the order and transferred the shares.
Yep.
I have a copy.
8th January.
No, my lord, 28 January. My lord, kindly have a look at that order, my lord.
8 was, 8 to 3.
28 January.
That's the main order, my lord, from where the my lord preferred the special leave petition, which was dismissed.
How many IAs you have in this case?
My lord, there are,
Paragraph 40?
my lord, paragraph 47 and 48, my lord, will kindly look, my lord, last page.
You are for the appellant.
Yes, my lord, I'm for the appellant. I'm for the appellant, my lord.
Paragraph
At my
40.
7, my lord. At my instance, my lord, the order was passed. This is, my lord, page 18 of 19, my lord, the last.
All right. Yes.
Yes, my lord, kindly look at, my lord, the order. Under the circumstances discussed in the foregoing paragraph, the court is of the considered opinion that until IA number 3982/2025 under Order 39 Rule 2A of the Code of Civil Procedure is decided, court is bound to set the wrong right, which is apparent from records. This, my lord, again, then accordingly, respondent number 3 bank is hereby directed to revert the 861,918 number of equity shares of B&L Limited, company from the demat account of respondent number 2, whom my learned friend is appearing for, bearing DPID number 300476, client number such and such, to the demat account of the late Hemendra Prasad Boru and Sharmila Vijay Shetty, bearing DPID number 301151 and client ID number 264245547 immediately. With the above directions, this interlocutory application is accordingly disposed of. Now, my lord, this was on my application, my lord, this order was passed. From this order, my lord, the respondent number 2 had preferred the special leave petition, which was, my lord, dismissed, my lord, by that order which, my lord, has seen 5th February 2026. That's, my lord, 5th February. So, my lord, this order has to be carried out immediately. My lord, they should first disclose, my lord, whether, my lord, they have done this, my lord, act or not. Otherwise, my lord, this will continue to be, my lord, in contempt of, my lord.
Your side is asking for time to file objection.
My lord, objection is, my lord, because they have, my lord, filed an affidavit, my lord, today. They have filed, my lord, a reply, my lord, today. They have served us. So I am on the question, my lord, this order has to be first complied with. It is outstanding order, which, my lord, the Supreme Court has affirmed, my lord, by dismissing the special leave petition.
My lord, some respect has been shown to the order passed by the Supreme Court, wherein
My lord, his special leave petition has been dismissed.
That the FAO and the suit will be decided expeditiously.
Yes, at my instance. My lord, my learned friend wasn't there. I was there.
Lordship, I'll have a look at this para 45 of this order, which my learned friend has read. Since the para 45, my lord, since the applicant has also filed another interlocutory application number so-and-so under Order 39 Rule 2A of the Civil Procedure Code, the plea of the respondent number 2 that as per the bylaws and rules of NSDL phrase, transmission of security and transmission of security carries different meanings may be examined in the same interlocutory application. However, as apparently it appears that the respondent number 2 in her request made on 7/11/25 to the respondent number 3 had suppressed the order just so this court is of the considered opinion that even the process of transmission of the aforesaid shares from DPID number so-and-so to so-and-so would amount to transfer in violation of the restraint order dated so-and-so passed by the Supreme Court. Now, it is in.
Yes, it is against my learned friend's client.
Madam, what I'm saying is, Honorable Supreme Court has said that this issue has not been decided by the Honorable.
No. I'm sorry.
This will be decided in the injunction violation petition. Now,
No.
therefore, madam, both the appeals will have to be heard together.
Well,
and because of the urgency shown by us, I mean, the Honorable Supreme Court has clearly mentioned that it has to be decided expeditiously. Now, injunction appeal, my lord, there is no question of filing any affidavit, etc. It will be decided on the basis of whatever the
well, the
petition.
order has to be complied with. I'm surprised my learned friend makes a
Violation is
submission.
concerned, my lord.
Well, I'm
So far as
sorry.
injunction violation is concerned, my lord. They have filed the application. We have filed our reply. Now the matter has to be heard. There is ways of scope.
No,
of
my lord, the order has to be complied with.
Rejoinder.
Well, kindly look at the
And
Honorable
if-
Supreme Court's
if-
order.
my lord, if they want to file a reply, I am not praying for a moment that
Well,
they should be restrained from filing any reply or rejoinder. Let them file. It takes within two days, 3 days. Let us have it on Wednesday. There is urgency in the matter, my lord.
Your application is regarding to which petition?
Their application,
Very-
My lord, what has
alleging
happened?
violation.
These shares were, an order of restraint order was passed by this honorable court. After the restraint order being passed, they transferred those shares. We filed an application under 151. They say the court directed the police return those shares. Once that order was granted, my lord, you'll see para 48, the court said you immediately transfer it.
Yes.
Now, what had happened against this order? They went to the Supreme Court. Supreme Court said, no, we are not going to interfere. We can only observe that this may be-
Dismiss the special petition. Mr. Saibala, show that
On
portion.
5th, this
Dismissed.
matter was heard. On 12th, they filed their reply. And today they say, now within 2 days you prepare. Why didn't you prepare in 2 days when this matter was heard on 5th?
My lord, lordship is
Well,
aware,
the
in an injunction
first-
violation before the
Well,
trial court,
Mr. Majumdar, can I
evidence is
just
recorded. And here they have filed their petition, we have filed our reply. That is the end of the matter. It is not a thing
My lord,
where parties will exchange affidavit one after another.
My lord,
We have
that's
filed
not the
our
issue.
reply. Whatever you had to say in the matter of violation.
My
of
lord, may I
injunction,
just
say.
make one
There is
submission?
no
My
question
lord,
of
I'm not
saying
finished.
you need
I'm for the
something more.
appellant. My lord, I'm
You
for
have
the.
already alleged violation. Your lordship will decide. Now, the Honorable Supreme Court has not said that this issue of difference between transfer and transmission has not been decided.
No, of course
It will
not.
be
That's not.
decided
I'm
in
so
the
sorry.
violation
No,
petition.
I'm so sorry. I'm so sorry, my lord. There's a direct order saying, my lord, the shares have to be transferred back. The Supreme Court has dismissed the special
I
petition.
am not
Kindly,
on
my
that
lord, look
point,
at,
whether
my lord,
what-
kindly
what
look at,
direction the Supreme Court is
look at
using, I am
paragraph
not on
3.
that. I am on the early disposal. Honorable
My lord,
Supreme
I am
Court
also on that.
clearly
I only
said
prayed for the
that it
direction.
has to be disposed
My lord, I only prayed for the direction. My lord, we were
They
there.
have to come up from where they have gone. Without they coming up, how can this hearing be dealt with?
So,
Because
but
what will
this-
happen to
but
the
if
order
this
to
is
this
the
My lord,
purpose?
kindly look at paragraph
something
3.
done elsewhere, Honorable Supreme Court's order will
Well,
not be complied
kind-
with. That will not be
Supreme Court had dismissed the
acceptable.
order of.
No, but the
Yes,
Supreme
kindly
Court
look at
has the same
paragraph
time
3.
said It has to be heard
Yes.
expeditiously.
Both,
My lord, kindly look at, my lord, paragraph 3 of
Let
the
us have
Supreme
it
Court
on
order.
Wednesday, Thursday, or maybe Friday, my lord.
My lord, kindly look at paragraph 3 of the order, my lord.
Why they are delaying?
Of my lord, the
in spite
Supreme
of
Court.
the
I am
specific
not
direction
delaying.
by the
Mr.
Honorable Supreme
Majumdar,
Court,
please.
my lord.
There's an order which has been
Kindly
passed by
bring
this
them
honorable
Wednesday
court.
Or if they want
My lord,
some
there's an
let it be
order.
Friday.
My lord, there's an order passed by this honorable court
Not
saying
beyond that,
immediately transfer the shares. Immediately. That's my lord, the order. The honorable Supreme Court has dismissed
See, you
SLP.
you went to the Supreme Court after this order was passed by this court to
Yes.
transfer
Yes.
the shares.
Yes,
Then after the Supreme Court passed an order to dispose of both the cases
yes,
expeditiously,
yes, ma'am.
you filed an application.
No,
No.
no,
So what-
no new filing, nothing.
Again?
We have only filed a reply to their application for violation of injunction. Now it has to be heard.
My lord,
Then let us hear it.
Yes.
My lord, one
My lord,
thing,
I-
my lord, say,
Why
kindly
they want
observe,
time?
there is a direction of transfer of shares, but where is that transfer?
You don't
Yes, and whatever is
Give
the,
the
my lord,
complete
my lord, I'm really
No, I did
surprised.
not comply.
My lord, I am
Compliance-
surprised. Compliance has to be by them.
and my lord, this direction of transfer, etc.
My lord, compliance has to be by them.
If the bank is not doing something for that, we should not suffer.
They have
There is
violated the
specific
order. Mr. Majumdar's client has violated the order. They
Lord,
went
will
up, my lord, to
kindly
the
fix it
Supreme
next week, my
Court.
lord, Thursday, let it be
My lord,
Friday,
they
my
went up to
lord.
the Honorable Supreme Court.
For hearing on Friday.
Friday, my lord, yes.
Friday.
Yes, ma'am. Let them file their reply.
My
One
lord,
week
my
time
lord,
is
kindly
more than
record.
enough.
Just
My lord-
final final disposal on Friday.
Yes.
My lord,
ma'am.
kindly record my submission. My lord, kindly record my submission. I'm so sorry, my lord. That, my lord, without complying with the order, my lord, they will have to comply with the order. The Honorable Supreme Court has
My lord,
dismissed their
this is
special
the problem,
petition.
my lord. They are again.
I have no,
Order
my lord, I'm
lost in
sorry.
past
My
order.
learned friend was not there. My lord, we were there before the Supreme Court. We were there before the Supreme Court.
Bank
At
is
our
delayed for some
instance,
technical reason, my lord, we should not suffer
what
for
technical
that. Let the
reason?
matter
Well,
be
there's an
heard.
order. He's in contempt of the order. Well, I don't understand. At our instance,
Appeal
this order was
cannot
passed.
deferred further by specific direction by the Honorable Supreme
Well,
Court.
at
Can
our
decide on
instance,
Friday.
this order was passed.
No,
Well,
no.
with reason to, my learned friend wasn't there.
Further
Well, we
delay
were
in the
there.
matter, my lord.
Well, they have to comply with the order, which is outstanding. The order says immediately,
Lord, kindly fix
28
it on
January,
Friday, my lord.
5th February,
Not on
specially
Friday.
petition has been dismissed. Lord, I don't understand, Lord, how they say this.
My lord,
With
what
great
is
respect.
Your submission will be recorded.
Well, kindly record my submission, Lord, on the question that they have to comply with the order. I've never heard, Lord, that after the Supreme Court dismisses a special petition, my learned friend comes and says, in spite of dismissal, let's just have the appeal heard out without complying with the order.
We'll
Well,
club the
it's-
cases together.
Yes.
My Lord, court's
Yes,
order.
I'll record your submission. But we'll fix this for hearing because it
Yes,
is at the stage
my Lord,
of
kindly
order,
and
so
my
we
Lord,
have to
direct
fix it for
them, my Lord,
hearing.
to comply with it.
And there's some disturbance from your side.
Yes, my Lord, I have no difficulty in fixing it for hearing. We'll, my Lord, file a reply, but they have to comply with the order. I'm so sorry, my Lord. This is because, my Lord, I should have been there, my Lord, because of this. My Lord,
I am appearing along with Mr. Banerjee. What Mr. Banerjee is saying is that the appeal has to be heard, but in the meantime, the order of this court, which has been affirmed by the Supreme Court, has to be complied with. What my learned friend Mr. Majumdar is saying, that I will order, let the order be with the side, let the appeal be heard.
My lord,
Nobody
whatever
is coming in the way of the
Not
appeal to
saying
be
like
heard.
Uh-huh.
Order has to be complied
Nothing
with.
as such has been said by him.
Mr. Malla, order without
This order
complying
has
with
to
the
be
order, and they
complied with.
they come with the objection on the day when the matter is fixed. The
Lordship,
time
kindly
has
fix it
expired
for hearing.
long time back. Why is Mr. Majumdar filing an objection on the day when the matter is fixed? The objection was due long time back. And the order of this honorable court, which has been affirmed by the Supreme Court, has not been complied by Mr. Majumdar's client and by the bank. Kindly direct
You
the
are getting
compliance.
1 week's time to
and
file
in-
reply.
Yes, but in the meantime, the order has to be complied with. The order cannot be thrown away on the side that just because appeal is to be heard, we will not comply with the order. Kindly,
Kindly fix it
My Lord,
on
kindly-
Friday, my lord.
my Lord, kindly direct them, my Lord, to comply with the order, which is the most priority. After, my Lord, I've never heard that, my Lord, after the
My lord,
Supreme
there
Court,
is
my Lord,
no fresh
Honorable
application for
Supreme
passing
Court.
any fresh order
No,
on
why
this
should
idea.
I? There's an order
There's one
subsisting.
Paragraph number 2, so we'll fix this for hearing.
My lord, my lord.
I'll not insist that he should pay or something of that sort.
Lord,
He will follow the direction of this court. Needless to say that the observations made in the impugned order will have no bearing on
Yes.
subsequent proceedings.
yes.
So
Yes,
this is one paragraph. So let's
Yes.
fix this for hearing and then it will serve purpose for
My
both
lord,
the sides.
my lord.
and, my Lord, the order has to be
Learned
complied with. I don't
counsel,
understand, my Lord.
He is Mr. R. Banerjee,
Our manager.
Learned counsel Mr. R. Banerjee,
senior
comma,
counsel.
learned senior counsel Mr. R. Banerjee, comma, learned counsel Mr. D. N. Sharma,
yes,
Yes, my Lord.
learned counsel Mr.
AK Sahib.
Huh?
AK Sahib.
A.K. Sahewala is present for the
Appellant.
appellant, comma. I'll pass this order in which case?
My lord, in the appeal, the
In the
matter will be fixed for
Appeal,
hearing.
my Lord.
FAO.
All are connected, my lord.
All are connected.
One order.
Club ko likhi.
Yes, yes.
And learned counsel Mr. T. Muzumdar, huh?
D.
D. Muzumdar,
My-
Mr. Senior counsel, no?
My lord.
Mr. D. Muzumdar is present, assisted by learned counsel.
P. Kaushik.
P. Kaushik is present for the respondent. It is submitted on behalf of the appellants that the respondents have not complied with the order of this court, with the order dated
28 January, my Lord.
28/1/2026 passed by this court in IS civil number 3983 of 2025. Full stop.
And
The
SLP was dismissed, my Lord.
respondents have preferred, and the
Yes, yes.
respondents went against this order up to the Supreme Court, and their SLP civil number 5070
My lord.
of 2026 was dismissed, which implies that the respondents have to comply with the order directing the.
It is not me, my lord, it is the HDFC Bank.
Direction is to
Both.
Direction is against the bank.
Which implies that the respondents
Bank.
have to take steps for compliance of the order.
Respondent bank, lordship, kindly indicate. I am not.
Respondent bank has to
Right.
take steps for compliance of the order. Passed by
Which, my lord, till date they have not taken.
But it is.
I'm paying for the bank. Why wrong submissions you make? Now, have you transferred? January 1, my lord, there has been certain restrictions put by NSDL. That is why we are not able to.
Lordship, kindly.
Kindly record this.
Yes.
Until 16th, thereafter they will transfer it. Kindly record that.
No,
My lord, they want some order. There is no IA, there is nothing.
But the respondents have not yet complied with the order of this court, full stop.
Well-
Learned Counsel, Mr.
Also,
R. Chakraborty is present on behalf of the HDFC Bank and has submitted that owing to
NSDL restrictions, man.
some
NSDL.
restrictions imposed by NSDL, no?
My lord.
The order could not be complied with, full stop.
Until-
In compliance of the order passed by the Supreme Court in SLP number 5070, SLP civil number 5070/2026, dated 5/2.
5-2.
2026, this case is fixed for
Hearing.
immediate for hearing immediately on urgently hearing.
My lord, interim order may continue, my lord.
On 20 kiman kola? 20 February? 20 February. Interim order shall remain in force till.
My lord, can we come back on the 27th, my lord, if my lord permits
Final
us?
disposal.
27?
27th, my lord,
R.
27th.
Chakraborty,
Two.
R. Banerjee is
R.
asking for
Banerjee.
27.
27th, my lord, I'll be
My
physically,
lord,
my
let
lord,
it be
there.
20th, my lord. I'm insisting
27th,
Monday itself, they are saying they want some more time. Lordship, kindly fix it on Friday. It's 20.
27th.
20,
My lord,
20.
27th,
Yes,
my lord, I was,
20.
my lord, I have to be there physically, my lord, 27th February, my lord, I was requesting.
Complied with, my lord.
My lord, we
20,
have,
my lord. 1
I
week
don't,
time they are getting.
my lord, 27th February, I was requesting.
No,
my
no,
lord,
no.
for-
20, my lord. I'm saying that let it be fixed on
No,
Monday.
this is, my lord, I have to come, my lord, from outside. I've always been there.
20th.
My lord, the order has not been complied with. I'm not, we'll take 1 week, my lord, to file an affidavit, then, my lord, can you fix it on the
1 week
27th?
they are getting. 1
Yeah.
week they are getting. That is why I'm saying, my lord, 20th, my
My
lord.
lord, I have some difficulty, my lord, on the 20th. I have some personal difficulty on the 20th. I'm asking for 27th.
Then let it be on 21 when the court is open. 21.
21st?
My lord, 21st also, my lord, I have seen, my lord, 20th and 21st, my lord, I have some personal difficulty. My
All
lord,
right.
there's 27th, my lord, kindly fix
My
it.
lord, 27 will be
I'm
too late.
grateful.
It will be 15 days.
27th.
Lordship, the Honorable Supreme Court is very clear. It said expeditiously, you have to comply with the order. Or
Yes,
let it be on
yes,
19th.
expeditiously doesn't mean, my lord,
22nd?
No, 27, my lord.
27th, my lord, 27th.
Same matter, my lord, pending at
No,
Gauhati.
no, 27 won't be possible here.
My lord, let it be 20, my lord. I'm saying in this case, rejoinder
It is not
necessary.
possible
They are
for me, Mr.
unnecessarily
Majumdar.
insisting on
Your
rejoinder.
special petition has been dismissed.
There is no scope for filing rejoinder. Let it be 20, my lord. 20.
Okay, I'll fix a date. I'll fix a date. Please make yourselves available. I'll fix a date.
My lord, not in 27, my lord.
No, not 27, not 28. I'll fix a date. 25th.
25.
No, 25th is not a hearing day. No.
Well,
24th. 24th.
24.
Your name? Land Council.
My lord, the interim order, my lord, should continue, my lord. And my lord, only one submission, my lord. I think, my lord, the bank said,
Remain in force till then.
my lord, the bank said, my lord, that they cannot comply with the order till the
My lord, let
16th.
it.
I have recorded it.
Till the
let it
16th,
be.
my lord.
My lord,
Till the
let it be
16th.
third,
The
then.
date
I'm
has,
the date.
the date has not gone down.
23rd. 4th and
No, my lord,
5th.
23rd, it's not possible. My lord,
23rd.
23rd, it's not
24th is
possible. my
hearing
lord.
day.
24th, 24th.
24th, my lord. 24th is a Tuesday, which
24th.
is a hearing
My
date.
lord,
24th, my lord.
I have some difficulty.
I have also some problem, my lord.
24th, my lord. Then, my lord, that's why I was requesting for 27th. My lord, learned friends don't want
26, sorry,
27th.
26.
26th, I'm fine.
26.
All right.
My lord, 26th, my lord, it will not be, my lord. Possible.
You won't be there on 26?
No, my lord,
My lord,
24th or
let us have it
27th.
on 20th. My lord, it's a, they are, my
No,
lord,
no,
they are
please.
asking for time because
My
the
lord-
bank has not complied with the order. For that, my lord, Honorable Supreme Court's order cannot be, my lord,
My
disrespected.
lord, I
That is
really
my
do not
submission, my
understand.
lord.
It's not being
They are having
disrespected.
enough time.
My lord,
They are
not being
waiting for
disrespected.
something else.
Expeditiously means, my lord, also the suit has been expedited. 20.
Let it be
My lord,
20, my
either,
lord, 20th is a very good day, my lord.
no, my lord, 28th, my lord. Either, my lord, 24th.
There
or,
is
my
no
lord,
reason for asking for further time, my lord. They are on a different.
I have
You will
personal
not available on
difficulty.
24, my lord, I will be not available.
Malab, we have to start on 24th.
My lord, we'll
We
start.
will start on 24th. The bank can come afterwards.
On 24th.
My lord, let it be
24th.
20th
24th,
or
grateful, my lord.
21.
24th.
I'm saying
24th.
either 20th or 21st.
24th.
24th.
Saturday, my lord,
24th.
working day.
Court has already said,
Mr.
Malab,
Majumdar, I have 24th, the court has said, my lord, we'll
we
accept
will be
24th.
coming from
24th
outside.
Saturday.
Malab.
Some
24th,
places do
ma'am.
not have working days on
No,
Saturday.
here it is working day, my lord. Lordship will fix it
My lord,
here.
we
only.
do not have, my lord, that. I'm in personal difficulty on 20th and 21st.
And say Saturday, my lord, it's normally there are very less matters on the list, my lord.
My lord, 24th, my lord, kindly put it on the
Kindly
24th.
keep
We'll
it on
be there.
24th, my lord.
We'll be there, my lord. 24th. I'm grateful.
24th, my absence may be.
Grateful.
Yeah, we will take some time. We will start, my
Then,
lord.
my lord, let us have it on 26. 24, 25, I have got difficulty. Let it be 26 then. It's a hearing day.
26 is not a hearing day. Or
Hearing
26. Okay, 26.
26.
My lord, hearing day.
26 is a hearing day.
Yes,
Everybody will be present.
Yes.
26th. Short date also.
My lord, my lord, we have filed an
My lord, interim order
written
stands
objection today,
extended.
my lord, against their application.
Saiwala.
3982. That may be tagged, my lord, in the record.
Learned Council, Mr. once more.
Response number 3, my lord.
Your name.
Check.
Arch of property.
Mr. Archagovati has submitted that an affidavit.
No, written objection against 3982, IA 3982.
An objection has been filed in connection with IA
82.
3982.
Always.
Interim order may be extended till next day, my
Okay.
lord.
Extended.
Grateful.
May it please your lordship, as per office dated 11 to 26, AD card has returned back lordship, as per respondent number 2 and 3, as per notice 11 to 26 lordship.
AD card is office note.
11 to 26.
What about office note 11 to 26? AD card?
AD card, as regard respondent number 2 and 3, AD card has been received back lordship.
Any note on AD card? Yes, my AD card received back with postal remark incomplete and insufficient address respectively and captured flag A. You'll obtain new address or what to do?
Lordship, we can.
Address is not sufficient.
Okay, lordship, we can take new address and fresh step will be taken, lordship.
You take fresh steps.
Yes, lordship.
Okay. Your name?
AB Castle, lordship.
Learned Counsel Miss AB Castle is present for the claimant. MSc appeal.
Yes, lordship.
Claimants or claimant?
Claimants.
Claimant and Learned Counsel Mr. SP Soma.
Respond number 1.
Is
Respond.
present for the insurance company. Full stop. Office note dated 11/2/2026 indicates that office note notice issued to respondent number 2 and 3 has been received back with a remark that address is insufficient and incomplete. Full stop. It is submitted by the learned counsel for the appellant that fresh steps will be taken. Full stop. Appellant may take fresh steps to issue notice to the respondents.
Obliged, lordship.
Number 2 and 3 returnable within 4 weeks.
Obliged.
Can no. Call for the original record from the tribunal.
Obliged, lordship.
Immediately call this item 22.
Please, your lordship. Well, pursuant to the order passed the last date, my lord, we have served the copy, my lord, by way of Dusty, my lord. We have filed an affidavit also to that effect, my lord.
Learned Counsel Mr. B. Kosik, no?
My lord.
Is present for the applicant and has submitted that notices have been issued to
To the sole respondent, my lord.
to the sole respondent. Notices which have been issued to the sole respondent to Dusty service has been received
Received.
by the has been served. It has been served to the respondent. An affidavit. Where is the affidavit?
Look, affidavit perhaps has not come on record, but they have filed one wakalatnama also.
Okay, you have asked to call for the affidavit, no?
Yes.
Or the affidavit is not on record, but the respondent has filed a wakalatnama. Okay, ready to place this affidavit on record. We'll call for the LCR.
Look, it's a delay condonation application.
For delay condonation. RSA.
RFM.
List after 2 weeks.
Please, sir.
Twenty-one to order the. Twenty-one to Hogan.
This matter was last heard on 16/10/25 as part heard, my lord. And thereafter on 18/11 was listed, but it was deferred, my lord. So, my lord, today we both of, I mean, like, a little accommodation, 1 week time maybe allowed.
1 week's time.
1 week, my lord.
As agreed by learned counsel for both the sides, list this matter for a hearing after 1 week, or should I give a date?
A date may be fixed, my lord. Otherwise,
Uh-huh.
can it be on- can it be
24th
on 26, my lord? 26.
Hey, হেৰি পৰা ললা নেকি হেৰি পৰা 80,000 পৰা?
26.
No, no. You are sitting here
My lord.
after 5 minutes,
No.
five
Fix a second.
5 minutes ahead.
Already.
You are sitting here, you have heard them. No, no. How they were fighting for 26 or 19 February. And that will be a long matter. I think so many days they'll take
Yes.
to complete their argument.
Already.
So on 19th.
Already.
এইটো কিমান আছিলে 12 ন?
May it please, your lordship. In this case, the appellants are the plaintiffs, lordship. They filed a suit of praying for lordship, that is prayer portion, your lordship will find page 13.
Appellants are the plaintiffs.
Yes, lordship. Ready to?
Your lordship may have a small prayer at this point, your lordship. Can it be done because the conducting counsel, he's in Delhi at this today, so we can hear them, and just our part we will do on the next date, your lordship. They can finish their arguments today, your lordship.
No, no, no.
And hearing.
What's the point?
Because I'm not the conducting counsel and he is out station, your lordship.
Okay.
Mehul Shah, Advocate Mehul Shah. That is the limitation. Otherwise, if it is extremely not possible, then I will continue.
Patients, he is appearing, so
Indeed.
I'm not aware who
I was
else is
for the
appearing.
for the IAN, we are agreeing for the urgent hearing also, and only for the final hearing. That is our humble prayer. We can also, if they are to continue with the arguments, but I will note down everything. Just for the reply part, we are seeking for 1 day. If it can be done in this manner.
In this case,
Or-
what happened, lordship, we have filed early hearing application that was allowed in his presence. So that date has been fixed in his presence.
We consented to it in a complete totality, lordship, but suddenly a matter came in Delhi, so he had to go to Delhi. And if this can also be done, lordship, any strict date that on this date, whatever be the situation, the hearing may be done next week, any date also, your lordship. We are okay with it.
Whether I should continue with my part, lordship. It may make it part hard, then again it will be.
It will come back to
uh,
me, and that
lordship-
if I may be there, I may not be there
Lordship, and your lordship have to recollect it again.
again and again.
Or any strict date that on this date, final hearing.
When will
Any
your
date of the-
senior be back?
He will be back on 16th, your lordship, on any date next week, your lordship,
On 16th.
on 16th.
There is a duration next week. Learned counsel Ms. R. Chaudhary is present for the appellant, and learned counsel Mr.
TL Oscar, your lordship. TL Oscar.
T.L. Oscar has submitted that leading counsel.
In that case, lordship,
mm.
can it be after 23rd Ramadan?
Any days, any
Can
days.
be, can be.
Can be.
Mr. Who is the senior? Who is the senior?
Mehul Shah, your lordship. M. Shah, Mehul Shah.
Mr. M. Shah is out of station. List this matter here for hearing positively on 24th too. Is it okay? 24th too?
24th March, lordship.
24th March.
No, no, March. March.
19 March.
No, after 21st. So 24th March. Yes.
24-3, positively without fail.
Sure, sure. Deeply obliged.
No more adjournment by the respondents, lordship.
Positively, I have
Lord.
no recorded.
And deeply obliged.
Deeply obliged.
Item 20.
May it please your lordship. This is a first appeal against order of granting injunction, my lord. Before going to the impugn order, as I just placed the brief fact of the case, my lord. The petition, the present appellant, he is the defendant in the main title suit, my lord. The defendant appellant, my lord, he is the owner of a big industry, big clean industry, my lord. And that industry, my lord, was taken on lease by the plaintiff, my lord.
Okay.
There is a lease agreement, your lordship will find at page 45. Sorry, my lord, page 30. Lease agreement.
He is, dependent is the owner of lease, no? Or owner of
Dependent, the owner of a
industry.
big clean industry, it is known as Ita Bhata. So that big clean, my lord, that was
Industry owner is defendant.
defendant, my lord, and defendant
Yes,
appellant
is plaintiff.
yes, my lord. This is the plaintiff, my lord. So there is a, my lord, lease agreement.
For how many years?
Your lordship kindly see that page 45 is the lease agreement. Initially, it was from 2023 to 2028.
From
My lord.
2023 to 2028.
8. Page 45, my lord. I'll just read the agreement, my lord.
Okay.
That was the fifth, has your lordship go, page 45, my lord. Page 45, my lord. On 5th day of April 2023, the Star Brick Industry, that was the first party, and Nazil Hussain and to Mofidul Hussain, these are the second party, my lord. There is a lease agreement. Your lordship kindly terms and condition, page 46. Page 46.
Okay.
Terms and condition. The both parties have settled the lease period for aforesaid big clean industry for years 23, 24 to 27, 28. The first condition. The both parties have fixed the settled of yearly rent, said big industry, 40 lakhs per annum. Today, the lease shall pay the rupees 40 lakhs, the lease including so and so, so and so. That the lease amount for the remaining sessions, 2024, 2025, 25, 26, 26, 27, 27, 28, shall be payable by the lessee to installment in but the lease amount shall be paid on or before 28 February for each session without fail. That all the relevant documents of the aforesaid big industry shall be maintained up to date by the lessee if so required. So that was the agreement, and as per that agreement, my lord, they took over and but ultimately, my lord, they failed to pay the amount in the time, my lord. On that occasion, my lord, we issued a legal notice to him, my lord. Lease deed and legal notice is issued, my lord. Page 52 is the lease deed legal notice, my lord. In legal notice, I have clearly mentioned in para 11 at page 54. Since you have default of payment of yearly rent for period 24-25.
Page 11.
Page 11, my lord. That is the internal page, my lord. It is started from page 52.
Oh, page 54.
Para 11.
Para 11, page 52 is start from page 52.
Page 52, para 11.
Para 11. No,
Hey, mommy,
54.
Dihol hobo argument.
All of, I'll take on
54, lordship. 52 size.
52, start from 52 and internal page, I have his running page 54, my lord. Running page, but that's
Para 11, okay.
Para 11. Since you have default in payment of yearly rent for period 24-25, the big industry, being lying the dock, you are a permit of so and so, you are now shall be dictated as a lien against the default and such you clients shall have every right to take over the possession and shall have the power to right to sell the big realizing the default area for the default. Presently, you have no right to use the tool, machinery, yard, dock, house, and promise of my client for your own purpose. So accordingly, my lord, there is another agreement. There is a supplementary agreement, my lord. That was in page 57. Because they says that they had replied, my lord, they are unable to pay because of their because of the business, my lord, down in that area, my lord. So they says that, and ultimately we are executed another lease deed, my lord. That is, my lord, additional lease deed. That is page 57. Page 57, my lord, your annex of 5, your lordship kindly see. Additional deed of lease. That is, heading is your lordship, additional deed of deed. And conditions are, my lord, page 60. Page 60, my lord. Between the parties, my lord, there is additional lease. Page 60, my lord. That has your lordship got page 60.
Yes.
That earlier rent of 40 lakhs only as fixed clause 4 is principal lease deed revised is now to rate of 27. Now it is, my lord, come down to that will
Lower to 27.
reduce to 27 lakh. Only for the session 24-25 and 2 which the lease shall not raise any objection. That are agreed by both the parties to the deed that the yearly rent of the said big industry for the session 24-25 shall be paid by the lessee to the lessor in the different installment, the manner as mentioned below. The first installment 10 lakhs, second installment 8 lakhs, and third installment 9 lakhs, total 27 lakhs. So that is the yearly revenue fixed for 24-25. And your lordship kindly see another clause, my lord, clause 5 and page 61. The GST of said MS Star Big Industries shall be paid by the lessee. Then, my lord, 62. The additional lease deed is valid and to be continued only for the session, that is 24-25 session, and it shall be terminated after ending of the session. That after ending of the session 24-25, if the lessee does not want to run the said MS Star Big Industry anymore, then they will have to provide intimation to the lessor by 15/4/2025. If after the end of the session 2025 lessee intended to run the said MS industry for subsequent session for both the parties shall with mutual understanding enter into the execution of the first additional lease deed pursuing the principal lease deed dated so and so. A fresh lease deed revoke the principal lease deed dated so and so and so. So your lordship kindly see the lease deed or fresh lease deed revoking the principal lease deed so and so. Both the parties shall abide by the terms and conditions mentioned in the additional lease deed so and so so and so. So these are the lease, my lord, second time. But she failed to, my lord, pay the
Second time also.
second time also, 23-24, my lord. Sorry, 24-25. So ultimately, my lord, only 10 lakhs rupees has been paid. The second and third were not been paid. So I repeatedly demand, say you just vacate it because you are not paying. I am the owner, my lord. I have to maintain it. This is my property. Then she straightway go to the court. And court for what? For, my lord, your lordship kindly, for damage. A suit was filed, my lord. That's page 85. The lessee, my lord, instead of paying my rent for the year 23-24, my lord, sorry, 24-25. So straightway file, my lord, the TS number 114 of 2025. So I filed WS. Your lordship kindly see suit for execution of lease agreement and for compensation damage for
TS number 11.
TS number 114, page number 85.
Suit for compensation of?
Suit for compensation of 4 crores 35 lakhs and 69,400. So your lordship kindly see the pair of the, my lord, that suit, my lord. Page 100, my lord. Page 100, my lord. There is the pair, my lord.
Two plaintiffs.
My lord.
There are two plaintiffs here.
My lord. Yeah, there are two plaintiffs, my lord, because they are, yes, they are under, my lord, big industry, my lord.
Page 100.
Page 100, my lord. For a declaration that the defendant is liable to pay the damage of a compensation amount 3 crores 65 lakhs 69,400 to the plaintiff. That is their first pair. Second pair, direction to be given to the defendant that according to the agreement up to 27-28, the defendant is to restrain from further disturbing in any way in the continuation of the Star Big Industry so and so and so. My lord, that is absolutely, my lord, uncalled for because already that by additional my lord release deed, that is no more up to 27, 28. That is for only that year, my lord. For a declaration of lost profit and for permanent injunction and for any other relief. These are the relief they have paid, my lord. Then, my lord, I file objection. And now, my lord, your lordship kindly see.
You filed WS.
I filed WS, I filed a affidavit against the order of temporary injunction, my lord, against the application for a temporary injunction, my lord. Now, my lord, that on 14/10/2025, temporary injunction was granted. And against that, my lord, I came before this honorable court and this honorable court stayed the matter, my lord. And record was called for and, my lord, appeal was admitted. So in that stage, my lord, today I am for a final hearing. Record was probably here, my lord.
Record আহিছে নাই? Record নাই আহে। Huh?
So when admitted, record has to be required. Because it was a,
There was no order for record.
so, my lord, probably there is a.
Already in injunction matter, lordship, everything is before your lordship. In the
No, I have
FAO lordship, everything was annexed, lordship. Injunction petition, objection by them, and injunction order.
Big question.
Only these are lordship. Certified
not required.
record not required, lordship.
That's
For that only lordship records may be
No,
not.
I'm ready to argue today. I'm not problem. I'm there because there is a order. If there is a order when admitted, I was not there, but I have seen the admission order.
Yes, lordship, on last occasion, my learned friend has shown that it was admitted.
Sometimes we ask if the records are required, then when the
My lord.
when it is said they're not required, then we don't call for the record.
Yes, lordship. In this case, this is the impugn order and this is a certified copy, lordship. And we have taken lease of the property, so lordship, we are suffering. So at our instance, this matter was fixed today for hearing.
No, there is no
My
question of
humble
suffering, my lord. I am because there your lordship kindly see how this order was passed, injunction order. My lord, I am the owner. They are not not paying anything, my lord. So they are not paying the rent, and now they came to the court, my lord, for compensation, my lord. So where is the question of injunction, my lord? Your lordship kindly say how this prima facie case is been, my lord, decide, my lord. Page, my lord, 139.
Learned counsel for the steps to issue notice, dusty mood. No record call kora nai.
No, there is a order in admission, my lord.
Calling records.
At the time of admission, when appeal was admitted. Admission order ko mo qualification.
At the time when it was admitted, records were not called.
Not called. But there is a order for calling of record. Or for admitted, there is a order. My lord, probably there is a.
Appeal is admitted.
311, lordship. Order dated 311, it was admitted.
No.
No, my lord.
Records were not called.
If your paying is allowed, there is a, yes, my lord, sorry. The land council for we have to respond on one and has paid for allowing the respondent to yes.
Because that
My lord,
records are not necessary.
My lord, injunction.
You have filed a WS?
Yes, my lord.
The written objection?
My lord, everything I have filed.
Plaint you have filed?
We have annexed, my lord.
Okay, then it's okay.
My lord. No, my lord, your lordship kindly see why this that impugn order on 14/10/2025. That is bad, my lord. Your lordship
Page,
can
which page?
page, my lord, 159, 139. Page 139.
Okay. Oh, this is the impugn order.
This is the impugn order, which I have challenged before this honorable court, my lord. The parties are present for their engaged counsel. This order was, my lord, these are all facts, my lord. Your lordship kindly, if required, I will read the facts, my lord. But I am.
Yes. Not required because.
I straightway will go to my lord, page para 27. Para 27, my lord. Prima facie case.
Okay.
143.
143. Now let us see whether there is any prima facie case in favor of the petitioner. The petitioner contended that their petition that the proposed party who is the owner of the state brick industry situated in Borapara, Bongaigaon had entered in a lease agreement with the petition on 5/4/2020 to rent the said big industry to the petitioner number 5. Here in respect of 23 bighas of land, the petitioner, after taking over the actual possession of the said big industry, would came to know that the said big industry was comprising 5 bigha, 1 kata 10 lesser land, which the petitioner had to take the rent of 4 bigha nearby the land, and different person from investing a huge amount. The opposite party has been continuously interfering with the lawful possession of the petitioner and peaceful conduct of their business in the said big industry. Sorry.
Yes, this is good. So you have agreed to allow big industry in 23 bighas of land, and then you have given only 5 bighas of land.
No, my lord, they have taken possession, my lord.
14 bighas.
My lord, that is not the issue, my lord.
Ah.
Then they, my lord,
They have
should
taken possession.
my lord. Business in said big industry, nothing. No, whatever the, my lord, in agreement, everything is there. Your lordship kindly see. Now, what now, my lord? The prima facie case is how they decided. The business in that said big industry, knowing notwithstanding the substantive agreement between the parties, the petitioner stated that their petition that they have invested more than 3.64 rupees so and so only in the business and have suffered substantial loss owing to the opposite party unlawful act. The lease agreement extended between the parties remaining valid for period 23-24 to 2028, thereby establishing a prima facie case in favor of the petitioner. My lord, that is not there up to 28, my lord. By additional affidavit, it is only for the 1 year. Because we come down. Your lordship can initially.
Yes.
So, my lord, prima facie case, how this prima facie case on basis of that, how they say that it is 24 to up to 2028, my lord? If they want to sell, want to proceed further, then there is another agreement has to be proceeded. That is as per the agreement of the second agreement. So, my lord, that line is prima facie, my lord. It is my lord. Out of my lord, it is perverse, my lord. Because as per the second agreement, earlier it is 40 lakhs. We come down to 24 lakhs, 27 lakhs in the second agreement. So there is that's why they abide by the terms and condition. There is a signature. It is a sale deed, my lord. Lease deed, and they agreed the terms and condition. They will in 3 installments. They will pay it for the year 24-25 in 3 installments. But my lord, your lordship kindly see, they have paid only 1 installment. Other left, my lord. Other did not even till today. They have admitted in their affidavit. They have filed affidavit. In fact, in this case here also, in first appeal also, they have filed affidavit. Yes, they have paid only 10 lakhs. 10 lakhs, they said one more 10 lakh 34,000. They said. But even then, they have admitted that second and third installment, they have not paid. They are the defaulter. Now, my lord, without extending the second lease agreement for 25-26, how they could give a finding in the prima facie case that it is, my lord, up to 28. So they have a prima facie case. And that is my first point, my lord. Second point is that, my lord, so prima facie case is not there, then others are redundant, my lord, since prima facie case is not there. How they can claim that it is up to 28 now? And they have quantified. So who will loss? Irreparable loss is in my favor, my lord. This is my industry, my lord. If they have, my lord, after so many years they have leave it, my lord, then who will suffer the loss without paying anything, my lord? Because my property is, my lord, they are destroying, my lord. Your lordship kindly see balance of convenience. Second, I will come to the second. First point, my lord, prima facie case. They don't have any prima facie case after 2025. Because they have violated the agreement. They did not pay the rent. Now, if they regularly pay the rent, why should I come to the court? Why should I object, my lord? So in that way, they don't have any prima facie case. Second, balance of convenience. Balance of convenience, they filed a suit for a quantified amount. The amount has already been quantified. Your lordship kindly see in their suit, if they own the case, what they will get? They will get, my lord, as their pair, your lordship kindly see 4 crores. My lord, your lordship kindly see the pair, my lord.
Yes.
So they have quantified, my lord. So they are if they own the case, they will get the quantified amount, my lord. So there is no question of prima facie loss, my lord. So their demand is, my lord, that's 3 crores 65 lakhs 69,000 and 400 rupees they're claiming. So they have pointed out, even they own, they will get it, my lord. So where is the question of prima facie, my lord? Where is the cause of balance of convenience? Because if I am not getting anything, then this night, this year, my lord, there will be pending. Without paying anything, they are enjoying the property. Can it be permissible? If defaulter can, my lord, have any prima facie case, my lord? If they say that, yes, for the year, my lord, 25, 23, 24, 25, I have paid the entire amount, my lord, then, my lord, they have a case. But they admitted, yes, they have paid only, my lord, 10 lakhs rupees, my lord, 10 lakhs 34,000. So my submission before your lordship, the balance of convenience, forget about, my lord, balance of convenience. Prima facie case is not in their favor, my lord, because the 24 terms is already over, 24, 25. And they are default. Now, my lord, how they can say that no, up to 28 our lease is there. So that is the line of funding of the line of trial court, that they have a prima facie case because there is a lease is up to 28. But that is prima facie wrong, my lord. Because in the second agreement, it is clear, my lord, terms and conditions they have agreed. So that's why, my lord, I'm before your lordship. There is no prima facie case. There is no balance of convenience. In fact, the balance of convenience in my favor, my lord. This is my property, my lord. While there is, we have lost an FIR also several, because they have stolen many property from that area, my lord. Now it is my possession, my lord. Already he has left, my lord. That prisoner, plaintiff have left, my lord. But it is my property, my lord. So a defaulter have any, my lord, prima facie case, my lord. That way, my lord, imaginary agreement, my lord, which is already not enforced, my lord. So my submission before your lordship, there is no prima facie case, and there is no, my lord, balance of convenience in favor of the plaintiff, but impugn order is bad on that count, my lord. In that line, my lord, I want to place one judgment, my lord.
That if you quantify the amount, there is no irreparable loss.
Because quantified, if they own, my lord, they will get same
I know
amount.
the judgment. You give it to me.
Oh, my lord. In this judgment, my lord, paragraph 5, my lord, clearly spell out, my lord. Your lordship, probably your lordship, my lord, gone through it several occasions, my lord, this judgment, my lord. Because in the injunction, that is the, my lord, injunction, my lord, prima facie case, my lord, how this deal with, my lord, paragraph 5, my lord. Your lordship.
Paragraph 5, no?
Paragraph 5, my lord. I copy that one, please. It will assist me. It will academic. 2012, 1 SCC, 75.
Made first development.
It is close.
You are giving two judgments or this one? Only one.
Only one, another one, my lord, that I will lordship kindly, because
Yes.
Citation
You read the judgment?
no, my lord, I'll give it to your lord, paragraph 5, my lord, that
And
actually I have being only one copy, my lord.
okay, other one, which paragraph?
Another one, that 11, 12 probably.
Paragraph 11 and 12. Okay.
So these are the two judgment, my lord, but these 2 points, my lord. So my lord, they defaulter, and they, my lord, that it is apparent that, my lord, that finding is totally wrong, my lord, because up to 28, my lord, is not there. So there is no prima facie case in favor of the plaintiff, and there is no question of any irreparable loss, my lord. Since it is already quantified, my lord, they will get it.
So you see, can you wait for me for 5 minutes? I'll come back.
Sure.
I'll come back after 5
No
minutes.
problem. No problem. No, I have finished my part. Now,
Yes. You finished your part.
I'm placing only that 1992 one SCC 71. Only one on that. Not this one. I have taken.
That other one is not required.
Yes, I have taken back this one.
Oh, you have taken back.
Yes. But this is slightly, my lord,
Different.
I'm sorry.
Not helping you.
Yes. No, it is on different line, my lord.
May I
Yes,
start,
yes.
Lordship? In this case, Lordship, it is admittedly they are owner of the brick-lin industry, Lordship. When they were unable to run the brick-lin industry, then they entered into an agreement with we two brothers, Lordship. We have taken a lease of 5 years, Lordship. That is lease, 5 years lease is at page, annexure 3, page 45, Lordship. There it is mentioned in page 47, your Lordship kindly see. Paragraph 7. That during the period of this lease agreement, your Lordship got it.
Yes, page 47.
Page 47, paragraph 7, last paragraph, Lordship. That during the period of this lease agreement, the lease shall run and manage the aforesaid brick-lin industry, the lessee, as they desire. In this regard, the lessor or his any relative shall not make any disturbance, interference to the lessee in any manner, provided that if any owner who has land within the compound of brick industry taken on rent by the lessor or any local people creates any disturbance, that is to be settled by the lessor, and due to disturbance of so-called owner local people, if the lessee would not run the brick industry, the lessor shall pay the damage to the lessee for the season, and the terms of the agreement shall extend for another season. So the claim of damage by the plaintiff is not illogical, Lordship. It was already mentioned in the principal agreement, Lordship. This clause was inserted only because that the owner has not the sufficient land in his occupation, Lordship, in the brick-lin industry. So he has taken some areas on lease from some other landowners, Lordship. So it was apprehended that they may create problem or the lessor may create problem. So to get relief of that situation, this clause was inserted, Lordship. And thereafter, Lordship, the notice was served upon us that you are not paying the rent. My learned senior friend has already read that para 11, page 54, para 11, that you are not paying rent. But this has no connection with this case, as because after this notice, additional agreement was executed. So after this notice, when additional Lordship agreement was executed, there was no dispute in between the lessor and the lessee, Lordship. So accordingly, both of them came to a decision, page 59. It is admitted by the lessor that, last paragraph, Lordship, and whereas on account of not having proper and profitable rate for marketing of bricks, the lessee has got a huge loss in the said bricks industry business during the season 2023-24. So it is admitted by the defendant himself that there was a great loss, huge loss, Lordship. And hence, considering the aforesaid ground of the market, both the parties to this did amicably have settled to revise the rent of the said Messer Star Brick Industry for the season 2024-25 as reflected in clause 4 of the principal lease deed. So there was a clause in principal lease deed, clause number
Page
4.
59, you are reading page 59.
59, Lordship.
Which paragraph? Third paragraph?
Last paragraph. And whereas on account of not having.
Lessee is that plaintiff.
Yes, Lordship. So there, as per the additional lease deed, Lordship, it is admitted by the defendant that owner that whereas on account of not having proper and profitable rate for marketing of bricks, the lessee has got a huge loss in the state.
You admitted initially, when defendants were unable to run the brick industry, the first agreement was executed.
Yes, Lordship. No, Lordship. First agreement is for 5 years.
Okay.
Not the defendants, the owner, who is the owner of the brick-lin industry, he was unable to run his brick-lin industry.
That is what.
So he leased out the entire brick-lin industry to us, Lordship.
Yes.
We are
That I
two
have noted
brothers.
down.
Yes, Lordship. We are two brothers.
Now again, now
And
the
in
plaintiff
that,
has incurred loss.
in that first agreement, Lordship, he already admitted that if any disturbance is there created in future, I will pay the damage. So he has taken that liability on him, lordship, because of the fact that in fact there was no 23 bighas of land. He has taken some lands from neighboring people on lease, and thereafter, on the pretext that I am handing over you 23 bighas, only he handed over 5 bighas of land. That matter was considered by the learned trial.
15 bighas.
15 bighas, lordship. So instead of 23 bighas, he has handed over less areas, lordship. So the lessees are suffering, lordship, as because they could not prepare the bricks, lordship, as per their requirement, and that is admitted by the owner he himself in his additional agreement, lordship. He stated that there was a huge loss in the said brick industry business during the season 2023-24, and hence considering the aforesaid ground of the market, both the parties of this deed amicably have settled to revise the rent of the said Messrs. Star Brick Industry as reflected in clause 4 of the principal lease deed. So clause 4 of the principal lease deed is page 47. First paragraph. That the lease amount for the remaining 4 seasons 2024-25, 25-26, 26-27 and 27-28 shall be payable by lessee in 2 installments, that is, but the lease amount shall be paid on or before 28 February of each season without fail. So earlier it was 40 lakhs when he was unable to pay due to loss. So it was agreed upon to 27 lakhs, lordship. So there is a denomination that first installment 10 lakhs, then 8 lakhs, then 9 lakhs will be paid by the lessee, lordship. Then your lordship kindly see page 61. That since the area of land measuring 22 to 23 bighas within the compound of the said Messrs. Star Brick Industry, as mentioned in the principal lease deed dated so and so, are not found available in the said compound. It is admitted by the owner, lordship, the defendant himself, and hence the lessor now be liable to provide the compound of the said brick industry, enhancing to total land measuring 23 bighas from its adjacent land within 15 days from the date of execution of this additional deed. So it is admitted that he could not provide the 23 bighas, lordship, at the time of first agreement. Next point, lordship, that the lessor shall provide NOC along with an authorized letter to the lessee for the purpose of opening an account. This is irrelevant. That if after end of season 2024-25, clause 8, lordship, page 62, or I am reading the entire lordship, the grounds, the ground 6, 7, 8, lordship, that this additional lease deed is valid and to be continued only for 1 season. So this lease deed is for only for one season 2024 to 25, and it shall be terminated after ending of the season. That after end of the season, page 62, lordship, 2024-25, if the lessee does not want to run the said Messrs. Star Brick Industry anymore, then they will have to provide an intimation to the lessor by 15/4/2025. We have not provided any intimation, lordship. That if after end of the season 2024-25, the lessee intends to run the said Messrs. Star Brick Industry for subsequent seasons, then both the parties shall with mutual understanding enter into and execute a fresh additional lease deed pursuant to the principal lease deed dated so and so, or a fresh lease deed revoking the principal lease deed dated 5/4/23. So we have not informed that we are not going to run this lease, and they have also not revoked, lordship. So the principal lease deed is still valid, lordship. Only a thing is required that another additional lease deed is required to be executed in between both the parties. So principal lease deed is still valid, lordship. They had not come forward to revoke that lead, lordship. Only by legal notice they stated that we are revoking your principal lease deed and the subsequent lease deed. That legal notice is there, lordship. But there was no revocation deed, lordship. So on this count, lordship, when the defendant suffered a lot, lordship, then they filed the title suit as already that clause was in the principal list deed, and along with that, an injunction application was filed. And to my understanding, Lordship, there is no perversity in the order itself, Lordship. Prima facie case, Lordship. Trial court has to decide injunction petition by deciding the three golden principles, Lordship. Prima facie case, it has decided that the petitioners contended in their petition that the opposite party, who is the owner of Star Brick Industries situated at Barpara, Bongaigaon, had entered a lease agreement with the petitioners on so-and-so to rent the said brick industry to the petitioners for 5 years in respect of 23 bighas of land, and the petitioners, after taking over the actual possession of the said brick industry, could come to know that the said brick industry was comprising only 5 bigha, 1 kata, 10 lessa of land, for which the petitioners had
It's
to
okay,
take in there.
it's okay.
So, Lordship,
Just I
it
want
is
to
a-
ask one question. See, if we'll decide this, it will decide this question, it will be like deciding the entire case, no?
Yes, Lordship.
Yes, my lord.
If we set aside this order, it will be like deciding.
No,
the
my lord,
entire
your
case.
lordship can listen, but they are not, we should not deciding, my lord. We are not the prima facie, my lord. Golden principle, my lord, prima facie case is not there, my lord. That is my submission. Your lordship can decide on prima facie case or not. Prima facie case for injunction and prima facie case for, my lord, trial. It's two different things, my lord. See, your lordship kindly see the second agreement, they have not even fulfilled that, my lord. They have to pay 27 lakhs, my lord. So they have paid only 10 lakhs. They are defaulter, my lord. They went to the court, my lord. So
But
they are
earlier that case was not invoked, no? That.
no revoke, my lord. Your lordship kindly see the principal clause is, my lord. Principal clause is, my lord, already modified to they are facing loss. That's why it come down to, my lord, 27 lakhs.
Only
From
for
40
the
lakhs.
rent purpose, Lordship. Only for
Yes,
the rent purpose.
land, only land, my lord. So your lordship kindly see. Your lordship kindly say clause 8 is very important, my lord. Your lordship, even, my lord, this agreement is not been fulfilled, my lord. Why they went to the court, my lord? My lord, the living, my lord.
Let us read this judgment. The judgment of quantification of the amount.
My lord, which one?
That 1992 judgment.
My lord,
quantification of
Dalpat Kumar.
whether it will amount to tantamount to irreparable loss.
Yes, my lord. It is in evaluation in favor of the, my lord. My lord. My lord, sorry, my lord, I bring only one copy, my lord.
Okay, I'll read it.
My lord, para 5, my lord. Because I will mean loss, my lord. Because my property, she is not paying any rent, and my lord, I am property is means damaging, my lord. Ultimately, they are, my lord, paying for compensation. So who will, my lord, all the instrument will be, my lord, will be defunction, my lord.
May I read, Lordship? Para 5.
Oh, yes,
Yes, you can read this.
Therefore, the burden is on the plaintiff by evidence illuminated by affidavit or otherwise that there is a prima facie case in his favor which needs adjudication at the trial. The existence of the prima facie right and infraction of the enjoyment of his property or the right is a condition for the grant of temporary injunction. Prima facie case is not to be confused with prima facie title, which has to be established on evidence at the trial. Only prima facie case is a substantial question raised bona fide which needs investigation and a decision on merits. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief and that there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequences of apprehended injury or dispossession. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties. If the injunction is refused and compare it with that it is likely to be caused to the other side, if the injunction is granted. If on weighing competing possibilities or probabilities of likelihood or injury, and if the court considers that Pending the suit, the subject matter should be maintained in status quo. An injunction would be issued. Thus, the court has to exercise its sound judicial discretion in granting or refusing the relief of ad interim injunction pending the suit. In fact, this says in my favor, Lordship.
Yes.
No, my lord.
There's nothing relating to quantify.
Yes, my lord.
And
Your-
Lordship,
yes,
I want to rely on one judgment
That,
that is.
my lord, the court will, while granting and refusing the granting injunction, my lord, it should be exercised for judicial discretion funded. The subsection himself is injury to which likely to create to the parties in the injunction, refuse and acquisition. Your lordship kindly see quantify. If he owned the case, he will get the money, my lord. But injunction, my lord, how this, your lordship kindly see the prima facie case, my lord, how that your lordship kindly see that then second agreement, my lord, even in today the defaulter. So in a defaulter came to the court. That instead of there come they say, I am suffering loss, you can another agreement for another year. They should have come before me. Without waiting for that, my lord, they went to the court, my lord, getting an instruction. Now even they not be, if they pay regularly, I have nothing to say, my lord. Why not they are not paying regularly, my lord? So a person who is a defaulter, can he claim that I have a prima facie case, my lord? Even in the second agreement, my lord.
May I
Now
submit-
they have not, they
Lordship,
admitted that I am only paid only 10 lakhs.
No, Lordship, that is a wrong statement. In FAO, they have made a statement that I have paid only 10 lakhs. By swearing an affidavit before this High Court, Lordship, the petitioner is, appellant is making a wrong statement. I have annexed all the money receipts, which shows that I have paid 10 lakhs 34,000.
Exactly, my lord.
So
That is now come out.
34,000
Yes.
where it has gone, Lordship. So he is
So-
making a false statement before this.
My lord,
Lordship.
there is not a false statement. Then why? That means they have admitted that they have not paid the another two installment.
He is disturbing, Lordship. We
No,
are
no, that's-
filing FIRs again and again, Lordship, for the disturbances created by, even Lordship, after getting stay from this court, Lordship, they illegally entered the bricklane industry and they have snatched the entire CCTV camera, Lordship.
My lord,
I am
they have
deciding
filed
to-
FIR, I have annexed, my lord, in fact.
Lordship, all the affairs, there are lots of affairs by both the parties. So to decide the dispute, the learned trial court had rightly granted injunction, Lordship. I have to prepare bricklane in the industry, then only I can pay the rent, Lordship. He is stopping me from doing the business, Lordship. And he has not yet revoked the principal deed, Lordship. There is no deed of revocation. Let them show that there is a deed of revocation, Lordship. And I am the plaintiff. I came to the learned trial court. So it is the duty of the learned trial court to protect the plaintiff, not the defendant. There was no counterclaim, Lordship, by them in my suit. And then, Lordship, the prayer portion they have stated in the prayer portion have nothing to stay with the Lordship injunction prayers. Injunction prayer is different, Lordship. Main suit, Lordship, while deciding injunction, the main reliefs on the merit, the learned trial court will not travel, Lordship. It will travel only within the sphere of the injunction, whether three golden principles were decided or not. Whether this order is perverse, Lordship. This judgment I have just cited, Lordship, what is meaning of the expression perverse. This Ramakant, I have just given, Lordship. Ramakant Ambalal Choksi, Lordship. Lordship, kindly see page 15. Last line, meaning of the expression perverse. They have to show there is a perversity in the order of the learned trial court. Page 15, Lordship, last line.
Yes.
Then it starts from page 16, Lordship. Any order made in conscious violation of pleading and law is a perverse order. In Moffat versus Gau reported in 1878 1 LR 1 R331, the court observed that a perverse verdict may probably be defined as one that is not only against the weight of evidence, but is altogether against the evidence. In Godfrey versus Godfrey, the court defined perverse as turned the wrong way, not right, distorted from the right, turned away, or deviating from what is right, proper, correct, etc. The expression perverse has been defined by various dictionaries in the following manner. So we have to see in the context of this judgment whether any of the content of perversity is there in the impugned order, Lordship. And thereafter, Lordship, paragraph 37. The wrong finding should stem out on a complete misreading of the evidence, or it should be based only on conjectures and surmises. Safest approach on perversity is the classic approach on the reasonable man's inference on the facts. To him, if the conclusion on the facts in evidence made by the court below is possible, there is no perversity. If not, the finding is perverse. Inadequacy of evidence or a different reading of evidence is not perversity. Seen in light of the aforesaid settled position of law, we are of a clear view that in the facts of the present case, the High Court overstepped its appellate jurisdiction under Order 43 of the CPC and substituted its own view for the one taken by the learned trial court without giving any categorical finding as to why the order of the trial court could be said to suffer from any perversity, capriciousness, arbitrariness, malafide, or having been passed in ignorance of the settled principle governing the grant of injunction under Order 39 of the CPC. It appears from a reading of the impugned order that what weighed with the High Court in setting aside the order of the trial court was the existence of pending litigations between the contesting parties and the alleged misuse of political power by the plaintiffs in creating hurdles for the defendants in the exercise of their lawful rights. The High Court failed to point out any perversity in the order of the learned trial court, which occasioned it to set aside the grant of injunction. We are of the view that the High Court ought to have limited itself to adjudicating the correctness of the order of the trial court on the settled principle of law and should not have taken into consideration any other extraneous matters, more particularly when the suit is still pending for adjudication on merits before the learned trial court. We are informed that after the High Court allowed the appeal and before this court granted interim relief, the defendants have transferred the suit property, that is during the pendency of the present appeal. So, Lordship, on this ground, it says that High Court on a first appellate court power, Lordship, should not interfere with the learned trial court order if there is no perversity. Lordship, there is no perversity. The learned trial court has discarded prima facie case, balance of convenience, irreparable loss, Lordship. We have invested a huge amount in this bricklaying industry, Lordship. Thereafter, they are disturbing. 40 lakhs we have paid. If we are unable to pay the rent for the first year, how we paid, Lordship? First year we have paid 40, then we have paid 10 lakhs 34,000. But in the FAO, they have stated that we have paid only 10 lakhs, Lordship.
But I admit it, my lord. I admit it. But even then, my lord, they said, well, I said 10 lakhs, they said 10 lakhs 34,000. But is it, my lord, they have condition of the second agreement is been fulfilled, my lord? That means they admit that they are defaulter. A defaulter, how they have a prima facie case, my lord?
I'm ready to pay, Lordship. Let me work.
If they have
That
paid,
is
my
the
lord, why
income.
should I come? Then why they go to court, my lord? Therefore, illegal intention, get an order from the court, and I'm in this side, I'll be defaulter.
They
So
can
if
file
they
counter
paid the
claim,
amount, my
Lordship.
lord, there is no question of any, my lord, litigation. I want money. I am a landlord. I get money that my tenant has been, but tenant not getting paid my money, and they go to the court taking an injunction. My lord.
Lordship, there
Then
is
let them pay
another
the amount in
provision
the
is
court,
there.
my lord, I'm ready.
They can
Let them
file
pay
a
the.
suit for eviction of the tenant.
That is the
They
issue,
can
my
claim
lord.
their
But they
rent,
are
Lordship.
violating the agreement, my lord.
They are not before the court. The plaintiffs are before the court. So court has taken
Now, my
consideration
lord, let
in the
them pay the
pleading of
money
the
here, my lord, in court, my lord, to installment.
Lordship. It will be
Really?
paid during the
That
pendency
was
of
the,
the
my lord,
court.
at the
If
time of
I
granting
am
my lord,
able to
injunction, this
work,
honorable court state we asked to her, you pay the money here, I will allow it. But still, my lord, I am the owner, I am not getting any, I have to face the case. And my lord, your lord, let him finish, I made my argument, my lord. I
Lordship,
reply.
kindly see the last paragraph of the impugned order, page 147, Lordship.
Yes, I have read it.
Lordship.
Last paragraph of the impugned order, I have read it.
Lordship, in this case, they were debarred from disturbing in the peaceful possession of the plaintiffs, Lordship. But after staying this order, they entered the Lordship bricklaying industry and they have snatched away all the CCTV camera and they have dismantled all the properties of the petitioners, Lordship. For that, we have filed FIR and thereafter we have filed a violation petition before the learned trial court, but it was not accepted as because pendency of this petition, Lordship. So if this court will go into the merit of the suit, Lordship, while deciding an injunction petition, Lordship.
No, it will like, you see, certain points will be like deciding the suit only.
Yes.
Yes, Lordship.
My lord, your lordship, kindly see, my lord. Please, section 38 of the, my lord, specific, my lord, perpetual injunction, when can be granted?
This is specific.
And before that, I am just submitting, my lord, that some of the instrument has been stolen away. I have filed a case, my lord. FIR has been registered, and now it is already, my lord, abandoned question that has been pending. And that is, my lord, there. And cases have also been registered also in my FIR, my lord. If required, I'll place everything before your lordship, my lord. And my lord, even when I'm giving a chance them, my lord, if they paid the entire rent before this honorable court, my lord, I'm allowed to run, my lord. Because I am losing rent, I am losing my property. In both hand, then prima facie balance of convenience is in my favor, my lord. My property is in an abandoned question, my lord. Anybody came and they
You
are
have not
stolen.
filed counterclaim?
No, that will come, my lord. That will come, my lord.
You have filed only written a statement.
But my lord, I have already written statement, I have a file, my lord. But your lordship kindly see, can a defaulter has a prima facie case, my lord, without my lord, they have first things to my lord. Yes, when I file this case, they should have come before this honor. Yes, I am ready to pay. Yeah, allow me to run. That was the they have violated the my lord that agreement on the basis of which they have filed a case, my lord. Now, your lordship kindly see section 38 of the specific relief act, my lord. Perpetual injunction.
Cannot a defaulter have no, why a defaulter?
No,
cannot
prima
have
facie
prima
case, my lord.
facie case?
No, they have to full pay. Suppose, my lord, their right will be accrued when they paid the rent. Their right will accrue then only. Otherwise, my lord, how they, your lordship kindly two things, my lord. Here it clearly spell out that the lease, my lord, after 2024, you have to give another lease.
Okay.
If you paid, my lord, entire amount. They are not paying entire amount as but a second additional, my lord, additional lease deed, my lord. And during that period, they went to the court. So they are getting protection from the court, my lord. But underhand, my lord, they are still remain not even why not they paying the rent till now? They should have paid it, my lord. And there is, and as on today, there is no agreement, my lord. What right they have, my lord? Because after 25, there is no agreement. Because they have not fulfilled the agreement, earlier agreement, and that's why second agreement they did not come forward. Now, my lord, they are in the court, my lord. So, my lord, taking the SQ of the my lord, what I am saying, why I am submitting the section 38 of the my lord perpetual injunction, when can be granted? Your lordship kindly see. The subject to the other provisions of the contained in the reference by the chapter in the perpetual injunction may be granted to the plaintiff to prevent a breach of an application existing in the favor of the holder expressly in by implication. When any such obligation arise from the contract, court shall be guided by the rules and provisions of the contract in chapter 2. When the defendant evade or threaten to invade the plaintiff right to or enjoyment of property, the court may grant a perpetual injunction in the following case, namely, when the defendant is trustee or the property of the plaintiff. B, where there exists no standard of ascertaining the actual damage caused or likely to be caused by the invention. But here actual damage, my lord, they have already quantified.
You are saying that perpetual injunction, when can be granted?
My lord.
So that this is clause B.
B, my lord. When the existence of the standard
So
of...
you see, now you are going to the plaintiff then.
No, their claim, my lord. See, they are payer, my lord. They are payer, my lord.
Then I will have to assess the evidence also then.
No, their
You are
payer
going
is
to the
no. Suppose, assuming that they are everything, whatever they stated in the plaintiff, that is they established, my lord, what they will get? They will get that amount of money. That is already ascertained, my lord.
Okay, I'll start.
That is my case, my lord.
I'll start dictating then.
My lord.
My humble submission before your lordship, this is a very reasoned order, lordship. In each and every case, if we interfere in the business of the learned trial court, lordship, proper orders will not be passed by them, lordship. Then I have gone through the order, lordship, everything were discussed, but the case of the plaintiff, the case stand taken by the defendants, and thereafter.
This judge passes a reasoned order, but now I'm not finding any case. I'll set aside.
Lordship, in this injunction.
I know him very well. He usually passes reasoned order, but here
No,
I'm
I
not finding any case.
personally don't have any idea about who has
But
passed this.
I'm setting aside.
Lordship. But lordship, this is a case where if we are not allowed to, lordship, work in the bricklayer, how we can pay the rent, lordship? And the principal rent agreement, they have not yet cancelled, lordship. They have not revoked the principal lease deed.
But it was only up to 25.
No, lordship, the principal lease deed up to 28. That is for 5 years, lordship.
Even then, I'm not finding any
It is
case.
modified by the second one, my lord.
And their case is not for rent, lordship. It is not a case for
This
rent,
is not
lordship.
my case, their case, my lord. This rent, my lord, we want money, they have paid the
If
money,
they
rent
want
here, my
rent,
lord.
lordship,
then
they
I-
ought to have filed a suit for rent, lordship.
Oh, that mean, my lord, they are waiting for.
You cannot step into the shoulder defendant.
And lordship, in the case, we have filed the case for lordship damage as well as for the injunction. So in our suit, the injunction
I'll
order.
not discuss the merits of the case.
Lordship,
I'll set aside the order, but I'll not discuss the merits of the case.
lordship, merit may not be.
I'll pass an order to dispose of the title suit expeditiously.
Lordship, that can be by both the party will reduce their evidence and thereafter it can be decided, lordship.
And then this I'll set aside.
Lordship, on the ground of lordship prima facie case.
No,
Already go ahead, apni.
no irreparable loss. The
Lordship.
loss has been quantified, no?
Lordship,
I know of a judgment, but he didn't give me the.
Man, I'll
appropriate
give that,
judgment.
my lord, the quantified judgment, my lord.
No, this is not the judgment.
this is in fact in my favor, lordship.
No,
That's
that is,
Kumar.
para 5 is mine favorable. Quantified judgment, I'll give him, my lord. Quantified is not there. Since it is quantified, law is there, matter. Is it
And
quantified? my lord, that
injunction,
can-
lordship, merit of the case, in fact, lordship, normally it should not travel to the merit of the case, lordship. Only there is a prima facie case or not, balance of convenience is there or not.
I'll not bring that on record. That is what I'm saying. Video conferencing. I'll not bring that on record. But you
Which
see,
one,
that
lordship?
amount has been quantified. Hearing at 2.
At 2.
This case relates to lordship, filing of a written statement. Firstly, shortly I'm briefing it, just short story. The short story is that lordship, firstly, that after 90 days, written statement was filed, that was not considered. Thereafter, after 7 months, lordship, knowing fully well, the written statement was not accepted by the court below. They filed a petition under section 151 CPC for accepting the written statement. Thereafter, written statement was accepted, lordship. And so far as CPC is concerned, lordship, exceptional in exceptional circumstances, written statement may be accepted after 90 days also. But so far as this 151 CPC petition is
Cannot be
concerned,
accepted mechanically.
mechanically, lordship, and more so, lordship, earlier occasion, the magistrate who rejected that written statement, not accepting the written statement, that particular magistrate was transferred. Subsequent new magistrate was appointed, and he accepted the written statement.
Without speaking orders or with speaking orders?
No, lordship, after rejecting their plea, lordship, firstly, they have not filed any petition.
Okay.
After 7 months, lordship, they have filed a petition under 151 CPC for accepting their written statement, and written
Let
statement
me
was
see the
subsequently
orders.
accepted, lordship. That
Do
is
we
why
have the
yes.
LCR?
No, lordship, no.
কিহৰ কাৰণে আছে? Admission কাৰণে আছে নেকি? Have you annexed the orders serially?
Lordship.
Page 43.
Impugn order and the earlier order rejected?
Rejected, lordship. I'm rejected.
Rejected by the earlier magistrate? Hearing কাৰণে আছে নে admission কাৰণে আছে এইটো? Admission আছে.
30 page 35, lordship, and XRC. I'm reading, lordship. Plaintiff is represented Hazira on behalf of defendant number 8 and 9 is filed.
LPR was not called?
LCR was not called for, lordship. I'm annexing the orders, lordship.
It's okay. If the orders are annexed, then it's
Yeah,
okay.
Hard and counsel for the
Which
plaintiff
page?
regarding page 35, lordship, and
35.
XRC. Page 35.
If the orders are annexed, there is no problem. এইটো ইয়াৰ argument টো আছে ন? Argument টো দি দিব লাগিব সেই ৰেকৰ্ডটোৰ লগত। লম্বা argument এটা শুনিছো ন? আগৰটো ইমানখিনি শুনাৰ পিছত পাহৰি গ'ল ডাঙৰ কথা হ'ব।
I'm reading, lordship. I'm reading the order.
Yes.
Plaintiff is represented Hazira on behalf of defendant number 8 and 9 is filed. Hard
Page?
8 and 9.
Page?
Page
35.
35, lordship.
Huh?
Page 35.
35. 31, 2024.
Yeah, lordship. 31 to 2020.
This is the impugned order.
Impugned order. Plaintiff is represented Hazira on behalf of defendant 8 and 9 is filed. Hard learned counsel for the plaintiff regarding acceptance of written statement filed by defendant number 8 and 9. Peruse the case record. It appears the defendant number 8 and 9 had submitted the written statement after expiry of statutory period of 90 days. Hence, written statement filed by defendant 8 and 9 is hereby rejected, and the suit shall proceed at the next stage. That that is the rejection.
Not the impugned order.
Not that is not impugned order. Impugned order I am annexing lordship at page 43. It starts from 43 lordship. 43.
Page 43.
43, that's the impugned order, Lordship, that I am challenging. The plaintiff is absent without any state, but I have had a Hazira lordship, but that was not reflected in the order. I have annexed that Hazira also. The plaintiff is absent without any steps. Defendant number 8 and 9 represented by
Page
their
53?
43. With today is the date fixed for necessary order on petition number 2918 of 24, since petition number so and so filed by the petition defendant Abdul Motin under section 151 of the Code of Civil Procedure, when it is submitted that 22/5/23, the instant suit was fixed for written statement of the defendant number 8 and 9, but due to lack of certain certified copies of defendant number 8 and 9, could not submitted the same on 2/5/2023, and that the suit was fixed on 26/6/23 for submission of written statement. It is further stated that the defendant petitioner submitted written statement 26/6/23, and the next stage should have been for issue document. It is further stated that later on the petitioner came to know, while order date 31/24, the written statement filed by the petitioner, petitioner defendant number 8 and 9 was rejected. The petition defendant has accordingly prayed for accepting the written statement filed by them and to fix the instant case for issue and document.
When the written statement is rejected, he must come for.
Yes, lordship.
Can the same court again accept the written
That is the
statement?
case, lordship. How they can review its own order.
Hmm.
It is lordship, civil judge junior review.
There was a technical error in the part of the CIS. There is a.
No, whatever it is. So same court has passed the order rejecting the written statement. So it was not it was the duty of the advocate to prefer and here in this case it will be revision.
Yes.
Prefer a revision.
Actually, what has happened, Lordship?
And in this case it will be revision. He ought to have preferred a revision petition.
The question was that, Lordship, that we have received our Lordship notice on 28/3/2023, Lordship. Thereafter, Lordship, we hope to have filed the WS on or before Lordship 28/6/2023, that is 90 days. Thereafter, Lordship, we have added as defendant number 8 and 9, Lordship. They will appeared on 3/4/2023, Lordship.
No,
Yeah.
but you see, when one court has rejected the written statement, then he must prefer a revision against the order. He cannot review his own order.
Lordship, he cannot review, can I?
We filed an 151 petition.
After 7 months, lordship. I have filed an objection regarding this, lordship. Lordship, may kindly see my objection, lordship.
Pankaj,
Kindly see the objection, lordship, filed by me, lordship.
no, I do not agree with this.